Thank you very much for that wonderful introduction, and I hope to live up to Emmanuel's recommendation that I'm a good teacher as well. So if I do speak too quickly or say things you don't understand, then please at the end do ask me questions, and any issues that you want to discuss, I'm very open and welcome to talk through questions with you. You're able to ask me questions in French. I will try and reply in French, and if that doesn't work, I'll reply in franglais, and when that fails, I'll have to go back to English. If it's really bad, you'll get Yorkshire, which is a dialect of English which no one will understand. So that will be my way of saying I don't know the answer, so I'll try this. It's a great pleasure to be here. I've enjoyed a wonderful welcome, and it's wonderful to see so many of you here this evening. What I want to do is to try and explain some aspects of the UK Constitution through a Brexit, and to focus in particular on the impact Brexit has had on the UK Constitution. And the starting point, if I can get this to work, there we go, is probably to show you this picture. Now, if you're wondering what this picture is, this is on the one hand what the Supreme Court normally looks like, just a building on a square. And on the other hand, what it started looking like during the Brexit process, and this was a quiet day. So this was early in the morning before the second Miller case, and if you look very, very carefully, you'll see me there, stuck in the middle of the media crowd, getting used to microphones, because suddenly the court took centre stage. We're not used to this in the UK Constitution. So one of the impacts Brexit has had is making us realise that we actually have a constitution. And not only do we actually have a constitution, but we have judges in the Supreme Court who are willing to enforce the constitution. Now, I'm afraid I couldn't find a picture I was able to use with the infamous spider brooch. But over there you have a picture of Lady Hale, who was until recently the president of the Supreme Court, and Lord Reid, who at the time was deputy president and who is now president of the Supreme Court. And they suddenly became media heroes. Lady Hale was able to just about get on the underground as long as she wore a big hat. Otherwise she was stopped, because suddenly judges who you don't notice, who you don't think about, were taking centre stage. And suddenly our constitution took centre stage. And in particular in the second Miller case, you get this statement trying to explain what the UK Constitution is or why it is so important. So the slides will be available afterwards, but I want to break down some of the aspects of this quote from the judgment. Now, we know we don't have a single codified document called the Constitution, but that doesn't mean to say we don't have one. What we do have is quite a unique form of a constitution, and there's three features I want to draw out to do with this aspect of the Constitution. First, we have a range of sources. So you'll see mentioned in the quote that there are statutes, there's common law, there are conventions, and there's practice. So there's a range of sources. The first two sources are legal. They're legal sources, they're sources of law that the courts can enforce. Parliament makes the statutes, but the courts develop and enforce common law principles. The second two sources are non-legal. So conventions are rules that arise as to how we operate in the Constitution, but they're not created by the law, they're not enforced by the courts. Or are they? So we'll talk more about that later. But traditionally, historically, that's not something that is enforced by the courts. You also get practices, rules that the House of Commons generate themselves as to how they behave. And we find these in the standing orders. They tell us how government works, when you have time in Parliament, when you have debates, and we have a huge volume called Erskine May, which sets out procedures and precedents of how Parliament works. So we can see them, but you can't enforce them in courts. They're just political sources. The second feature is its flexibility. The UK Constitution is flexible. It changes over time. It modifies to situations. So Brexit doesn't break the Constitution bends to accommodate Brexit because it's flexible. But then that begs the question, is it so flexible that it no longer performs a function as a constitution? because it's no longer enforcing constitutional standards. They can just be bent and manoeuvred rather than controlling how governments act. And the third feature is the feature that's become really prominent since the creation of the Supreme Court. The court plays a role. It is there to protect constitutional principles. Those constitutional principles that come from statutes or that come from the common law can be used and enforced by the courts. So Brexit has brought that to the forefront. We have a constitution, the courts play a role, but it's also illustrated a number of tensions that I want to draw to your attention at the moment. And there's three tensions that I want to look at. The first I'm going to call the tension between Westminster and the Supreme Court. And by this I mean a tension between law and politics. We have this range of sources. We have legal sources and political sources. But when should we use law to control the government? And when should we use politics? How does this work? The second tension is what I've called a difference between Westminster and Whitehall. And I'd love to claim that this was my phrase, but this comes from a colleague of mine at Cambridge, Professor David Howarth. And he uses this to explain the tension between government and Parliament, between the executive and the legislature. Westminster visions put more power in the legislature. Whitehall visions of democracy put more power in the hands of the executive. And this tension has played through the Brexit situation. The third tension is the tension of the union. The UK is not a unitary state. It has been a union for a long time. It's a union between nations and provinces or territories. So we have a union between England, Wales, Scotland and Northern Ireland. So up there are the flags that explain this element of the union. The English flag, the Scottish flag, the Welsh flag, and the most neutral flag I can choose for Northern Ireland, which is the flag of Stormont, the Northern Ireland Parliament, to give you an idea of the different tensions between these component parts. Again, Brexit has placed this under tension. We know that the referendum voted in favour of leave, but if you break that down to the component nations, England and Wales voted to leave, Scotland and Northern Ireland voted to remain. So the result itself exacerbates those tensions between the different component parts of the nation. And I want to also explain, I think there's a deeper fundamental tension underpinning this all, which is this tension between Parliament and the people. How far does the UK have a representative democracy, which focuses on the institution of Parliament, and how far is it about the people? And what happens when we have a referendum and direct democracy that reaches an outcome different from the one Parliament expected? Well, Brexit explains what happens. And it also explains some of these dangers of having a flexible constitution, because sometimes that means that aspects of populism can start to take over. And instead of getting the right balance between the institutions and the people, you get the institutions manipulating the will of the people for their own political ends. That's the danger of populism. And my suggestion is that some of those dangers are apparent in the UK Constitution. So how am I going to talk you through these? I'm going to start with the tension between Westminster and the courts, between politics and law. And I'm going to talk you through the most recent case to explain how this tension came. So this is the second Miller case. And this is where you had a challenge brought by Gina Miller and by Joanna Cherry against the decision of the Prime Minister to suspend or prorogue Parliament. And what this is illustrating is these different sources. We know we've got common law, statutes, convention and practice. Law, common law, statutes, politics, convention and practice. But how do they interact? How do they regulate what goes on? And this was the issue that arose in the Miller case. So the question that arose was this idea, this advice of the Prime Minister to prorogue Parliament. Now, I can't translate this because it's a very unique, odd British thing. So I'll explain later what prorogation means. But for now, you have to understand it as a form of suspending Parliament. So Parliament is not going to meet. and the advice from the Prime Minister that he was going to suspend Parliament sometime between the 9th and 12th of September and ending on the 14th of October. Now that's quite a long period for Parliament to decide it's just not going to meet. Not only is it a long period, but it's a crucial period, because at the time, exit day was the 31st of October. So for a period of 5 weeks, in the 8 weeks to exit day, Parliament was not going to be sitting. That was the advice. That was what prorogation would achieve. So the idea would be, also at that stage, you're probably pushing yourself in a situation where if there wasn't all that much time for Parliament to meet and debate, would there be enough time for Parliament to meet and agree all the things we needed to agree to leave with a deal on the 31st of October? If not, would that be pushing the UK towards leaving with no deal? So not just was Parliament not meeting, but it also had huge impact on the outcome for whether we'd be leaving with a deal or no deal on the 31st of October. Once the prorogation was announced, Parliament pushed back, and we got the European Union Withdrawal No. 2 Act 2019. It's not easy to say, so sometimes I might use its nickname that the Prime Minister gave it, which is the Surrender Act, and I'll explain why he called it the Surrender Act. But this was a pushback to try and push back against leaving with no deal. And it set requirements on the Prime Minister and said, okay, if there has been no vote in the House of Commons, either to leave with this deal or to leave with no deal by the 19th of October, then you have to go and ask for another extension. And the other extension will be until the end of January. So this legislation was enacted and then Parliament was prorogued. So we end up with no Parliament. Now, prorogation is important because of the way the UK Parliament works. At the moment, Parliament is elected for a fixed term of 5 years, but we break that up into a series of sessions. So they're not there just for the 5 years and you never stop. You have parliamentary sessions. You introduce legislation at the beginning of a session, and if it's not been enacted by the end of that session, it dies, unless you take mechanisms to bring it back next time. But the default position is if it's not been enacted within the end of the session, the legislation stops. So you have to push your legislation through in that session. And the importance of prorogation is if you prorogue Parliament, it's the Prime Minister alone that decides this. The Prime Minister gives advice to the monarch decides to prorogue, and normally the monarch will just do what the Prime Minister asks. There is no say for the House of Commons, which contrasts with a recess, which is a break which the House of Commons agrees to. So it's just the government. All the committees stop. So the committees that scrutinise what the executive are doing stop. They're not there anymore. Legislation lapses, whereas if you had a recess, it doesn't. If you have prorogation, you have no House of Lords. If you have a recess, the House of Lords can continue. So prorogation is very drastic. Executive alone, no Parliament sitting, no committees, legislation stopping, no House of Lords being able to discuss what's going on. So you can see it was quite a drastic impact to prorogue for 5 weeks. But the argument was, but what's the point? What's the problem? This is just political. Prorogation is political. The Prime Minister decides for political reasons when he's going to prorogue. How long you can prorogue for is just a political choice. If the politics allows me to prorogue, I'll prorogue. If it doesn't, it won't. The purposes of why you prorogue, it's all politics. Politics will decide why you suspend Parliament and when you don't. So there's no space for law. But the argument on the opposite side was, well, what if you end up proroguing for so long, Parliament never, ever really meets? It meets for one day, no laws are passed, and it goes away for the rest of the year, and then meets again the following year for 1 year, has a party, and you can see the consequences. If you can do that, and there are no limits, are you completely undermining democratic accountability? Also, what if your purposes are wrong? What if you lie? What if you say your purpose is for one thing, but actually it's to achieve something else? Shouldn't law be there to stop you lying about your purposes of prorogation? Or what if prorogation itself is being used completely to undermine democratic accountability? Is that an improper purpose that the court should control? And that set the debate for the case. And the Supreme Court had to decide, is this political? Is this legal? Can we intervene? And the reason this case is so important is because the Supreme Court said very strongly, we set the limits of prorogation. Yes, details might be political, but nevertheless there are key constitutional principles from the common law that we use to constrain how prorogation works. We have parliamentary sovereignty. Parliament is sovereign. You cannot act in a way that is going to undermine Parliament's ability to do its job. We have parliamentary accountability. The members of the government are accountable to Parliament. Parliament is accountable to the people. So you cannot have a situation where prorogation is for so long at such a crucial time that its effect is to seriously undermine parliamentary sovereignty and parliamentary accountability. That would transgress the proper legal limits. Now, we accept that that might be justified. So it may be possible for the government to justify why it's proroguing for so long, and we'll include that in our legal limits. But on the facts, you gave us no reasons. The Supreme Court concluded that the government had given not only not a good reason, but no reason whatsoever for proroguing for so long in these circumstances. And so, therefore, it was void, or in the wonderful language of the court, it was as if they had wandered in with a blank piece of paper. Okay? You come in and say it's prorogued. No, it's not, because you never had the power to prorogue, which meant Parliament could go back in to sit the next day. So you can see, understand now why the media were there and why it was so important and why it was such a crucially important case. But because our constitution is flexible and because it varies, how far is this still true? The very next day, the Prime Minister made it very clear in Parliament that he thought the court was wrong. As far as he was concerned, this was a political issue, not a legal issue. He just prorogued in exactly the same way that everyone else did. Politics controls this. Politics has said it was okay, so there's no space for the court. Now, he did respect the decision of the court, but as far as he is concerned, it was wrong. This is not about law, this is about politics. Not only were they wrong, but because they were wrong by seeing this as law, what were they really doing, says the Prime Minister? People at home know what is going on. This is about thwarting the will of the people because you're trying to stop Brexit. That's the reality, and that's a suggestion in his quotes. And then he mentions the Surrender Act, the act that was forcing him to notify what was going on. So you can see, much as we might want to set legal limits, if those legal limits are not accepted by those in power or questioned, so they may be accepted, you'll adhere to the law, but you're questioning how far law should be intruding in these constitutional principles and how far really it's all about politics, not about law, not a space for the court to occupy. We also have a further illustration of this in the Prime Minister's reaction to the Surrender Act, the European Union Withdrawal Act number 2. So if you recall, this required the Prime Minister to extend the negotiation period of Article 50 in certain situations. Those situations were met. There was no vote either in favour of the withdrawal agreement or no deal by the 19th of October, despite sitting all day on that day, which was a Saturday, to try and get this agreed. So we then have public statements by the Prime Minister that he doesn't want to comply with this. He does, but the way he complies is interesting. So he sends not one letter, but 3, okay? And the first is a photocopy of the wording set out in the legislation that he has to send to the European Council. So I have to send this, here's the photocopy, here it is. and that goes off to Europe. And it's accompanied by, and that's not signed, that's just a photocopy of the wording in the legislation. And that's accompanied by 2 further letters. The second letter explains the context. This is a piece of legislation, I'm required to send you this, so here it is. Okay. The third letter is a signed letter by the Prime Minister saying, well, I've sent you this letter, but the government policy is that we are going to leave with no deal on the 31st of October. But I have to send you this letter to request an extension because the law says I have to do so. And that was what was sent. So you comply with the letter of the law, as the law is requiring you to do, but you're not happy about it. And you're also suspicious about this particular act because of the way it was enacted. This wasn't initiated by the government. This wasn't the government initiating legislation. This was someone else, backbench MPs, initiating legislation. So you're starting to, on the one hand, you can see the court strongly saying there are legal principles, we will enforce them. But on the other, that hasn't necessarily been accepted. And the pushback is this isn't really the role of the court. And in a flexible constitution, it can be very hard for the court to say, well, this is my role. The constitution empowers me to do this. So you're constantly having this debate about what is the proper role between law and politics. And this debate is continuing. So in the Conservative Party manifesto, you get a suggestion that what happened last year wasn't really what should be happening. So they're proposing constitutional reforms, looking at prerogative powers, looking at the role of the courts, looking at the role of Parliament. So you can see there isn't necessarily an acceptance. A flexible constitution enables you to enact a different law to move it back away from the growing forms of legal controls. Okay. This brings me to my second tension. Westminster against Whitehall. When we think about a representative democracy, are we more concerned with the legislature controlling the government, or is the job of the legislature to shore up the government? The government has a majority of the seats, it has the ability to initiate its programme, so it's the job of the legislature to shore it up and make sure it achieves its outcome, and that's the Whitehall view of representative democracy. Now, the Surrender Act illustrates the way in which something quite drastic happened in last year, and it brought to attention all these practices and rules within the House of Commons, because this was not initiated by the government. The Surrender Act, as the Prime Minister likes to call it, was initiated by private members, by backbench MPs and MPs who are members of what the same party as the government, but not part of the government, and opposition MPs, MPs who are members of parties in opposition to governmental parties. Now, normally, this is nigh on impossible to achieve. There are very, very strict rules of when you can have private members' bill. You have a ballot, normally 20 are chosen, they'll never get through. There's a 10-minute rule where you can stand up for 10 minutes and propose a bill, and that's pretty much as far as you'll ever get. And really, private members' bills only tend to succeed if the government backs them. So how did this one get through, and how did it get through so quickly? Well, they did something cunning. And the reason it's very hard to achieve anything if you're a backbench MP is because the government controls time. Great, if you can control time, you can control pretty much anything. And that's what Standing Order 14 does. So this rule of the House of Commons prioritises government business. So when you're thinking about what are we going to do in Parliament today, the government will stand up and say, we're doing this, this is our business, this has priority, that's the end of it. And there are some rules that it has to abide by, like recognising when you can have private members' bills. So 13 Fridays a year, private members' bill take priority over governmental business. But other than that, tends to be governmental business wins. It wasn't one of those Fridays. So what happened? Well, they found another standing order, Standing Order 24, which is very long and complicated, but the gist of it is you can raise an urgent issue. So they raised Brexit as an urgent and pressing issue.
And normally when you use this standing order, you raise it just to have a debate. So you have a debate to say, this is a very difficult, pressing, urgent issue, let's have a discussion about it. And there's normally not a vote. But the Speaker is able to determine whether you can put a motion or not. And he decided that you would be able to use this procedure not just to have a discussion about an urgent issue, but to raise what we call a substantive issue. You can vote on it and it has consequences. You're not just talking, you can do something at the end of your discussion and your talk. So what did they do? They used this standing order to debate an urgent matter, Brexit. They allowed them to propose a modification to Standing Order 14 to say, well, today we're not going to prioritise government business. I'd like you to vote and decide whether today we prioritise something else. So rather than doing what the government wants us to do today, I'd like you to vote for us to do something else. And what I'd like you to vote to do instead is to pass this Ben Burt Bill, as it then was, which then became the European Union Withdrawal Act No. 2. So I want you to spend today discussing all the stages of this bill so that we can push it through Parliament in one day. And because the Speaker allowed this to be discussed, the House of Commons voted in favour of letting this happen. It meant this private member's bill suddenly took priority, was discussed in one day in the House of Commons, then went through to the House of Lords. The House of Lords then agreed to suspend its rules to allow it to be pushed through the House of Lords, and then it became enacted through very, very quickly. This is unprecedented. You do not have the Commons, the legislature, pushing back in this way and enacting private members' bills and overriding the prioritisation of government. And you can see a move, a very strong move away from Whitehall towards Westminster. Parliament has more power, government has less power. Parliament is better able to control what is going on. And this is recognised by the courts. And that's another reason why the prorogation case is so important. It's not just because you've got the courts imposing legal limits, restricting government activities, but by looking at this principle of parliamentary accountability, the court made it very clear that the way we see this is Westminster, not Whitehall. Representative democracy is about the government being accountable to the legislature, to Parliament, because the Parliament is accountable to the people. That is what parliamentary accountability means. It's a very strong statement that there's a preference for the legislature to be controlling the executive, not just shoring up what the executive does. Now, all this happened in September of last year. So when I was originally invited to give the lecture, I had no idea this was going to happen. So this gave me a lot to talk about. But things move quickly in the UK Constitution. Okay? We no longer have a situation where we have a minority government, which enables the legislature to take control because it can get enough votes. Since the December general election, we have a strong majority government. And you can already see moves back towards Whitehall rather than Westminster. And the best illustration that I can give of this is the European Union Withdrawal Agreement Act 2020, which was enacted in 3 weeks, which is our way of ratifying and agreeing to the withdrawal agreement so we could leave on the 31st of January with the withdrawal agreement. And we're currently now in the implementation period, which will last until the end of this year. What I want to draw your attention to is sections that are taking control back towards the government. So when I look at section 31, section 13 of the European Union Withdrawal Act empowered the Commons to have debates and votes on the withdrawal agreement. They had to agree it. If they didn't agree it, then you had to have debates and discussions as to what would happen next. That's been repealed. That's not going to happen with this next agreement, on the future relationship. There isn't going to be the same ability of Parliament to have votes on these discussions. An earlier version of this legislation before the general election would have required a minister to go to Parliament to seek an extension. So if we needed an extension, the minister would be able to say, I think we need an extension, I'm going to go to Parliament and see if Parliament will approve an extension of the negotiation period. No more. The current legislation says the minister cannot agree to an extension. So instead of saying we can ask Parliament, you can't do it at all. So again, it's putting the power back in the hands of the government. Also, they can't consent to the written procedure. So when you have joint committee meetings, you can't have the written procedure with evidence and writing, which could then be communicated down to the Commons, who could then raise it in debates and discussions. It's all going to be held non-written. So you won't see what's going on, which makes it harder to hold them to account for what's going on. And there's a strong assertion that Parliament is sovereign. We're not sure why this is there. We thought we knew this, but Section 38 tells us that Parliament of the UK is sovereign. A strong assertion, again, moving away towards politics. Parliament, what they do is important, not necessarily these legal restrictions. And all forms of parliamentary oversight over the future trade deal that were in the original bill, gone. So it's moving away from parliamentary oversight towards governmental control. Away from Westminster, back towards Whitehall, all in the space of about 4 months. It's really hard to keep track of what's going on in the UK Constitution. It's all we do now. What's changed today? And makes it very difficult to teach. So you turn up and you say, here's a bill, let's have a look at it. And then next week you say, and it's now law. What? So third tension I want to draw to your attention is the tension within the Union. And I've already explained why this has arisen. England and Wales voted to leave, Scotland and Northern Ireland voted to remain. Now, the difficulty and why this has grown in tensions is because of other aspects of sources of the UK Constitution, conventions, and how they operate and how they work. In order to have a system within the Union, we have a system of devolution. And this means that although Scotland, Wales and Northern Ireland can enact legislation in their specific areas, Westminster can also enact legislation in areas that have been devolved down to the devolved legislatures, because Westminster has to say supreme. So it can decide what gets devolved, it can change it, and it can legislate in areas that have been devolved, that have been passed down to Scotland, Wales and Northern Ireland. But the convention is that if they do this, they get the consent of Scotland, Wales or Northern Ireland. But it's a convention, it is not a law. So what happens if you break it? Well, in Miller, they had to think about, in the first Miller case, they were looking at, do we need legislation to trigger Article 50, to empower the minister to notify the EU of our intention to leave? And if legislation is required, would this be devolved, so you need consent? And the Supreme Court concluded, yes, there is a need for legislation, but legislative consent motions and the civil conventions are just conventions. And they explained that judges are neither the parents nor the guardians of political conventions. They are merely observers. They don't create them, they're not their parents. They don't check them, they don't enforce them, because they're not their guardians. But they do recognise they exist. And sometimes they can indirectly have an impact by telling you the facts to which we apply the law. But we cannot enforce them. So if you break the convention, legally, so what? Legally, it's not an issue because you can't legally enforce the convention. even though it looks like we've made it legal. Because the Scotland Act 2016 Section 2, and now also the Wales Act 2017 Section 2, tells us that it is recognised that the Parliament of the United Kingdom will not normally legislate with regard to devolved matters without the consent of the Scottish Parliament or the Welsh Assembly. That's the Sewell Convention. We have recognised it. But by recognising it in legislation, the court said what we have recognised is that it is a convention. So we've recognised it exists, we recognise there is the convention, but we have not made it legally enforceable. This is not law. This is politics. Why is that a problem? Because the European Union Withdrawal Act 2018 was enacted without the consent of the Scottish Parliament. Their consent was sought, a legislative consent motion was proposed. Scotland did not give consent. Originally, Wales also did not give consent. Both were concerned that when powers came back from Europe in devolved areas, they weren't going back to Scotland and Wales and Northern Ireland, they were going to go back to Westminster for 2 years and then go back to Scotland, Wales and Northern Ireland. And this concern eventually led to the legislation being changed. So the legislation we have, the powers do go back to Scotland, Wales and Northern Ireland, but the government can enact delegated legislation to take some of them back to Westminster for 2 years. But don't worry, they have to have consent if they're going to enact the delegated legislation. But consent is defined as you ask, and even if they say no, that still counts as consent. Yeah, I'm not going there, okay? Do not apply this across to other areas of the law, please. But this is how it's seen. The European Union Withdrawal Agreement Act 2020 goes further. None of the devolved legislatures gave their consent. But it's an act, it has force, now, can you imagine if this happened in Belgium? We're going to ask you for your consent, but even if you say no, it's okay, we're going to do it anyway, and you can't make us ask you, and it doesn't matter. Yeah, it's a very different understanding because it's devolution, not a federal structure. And because it's devolution, you cannot undermine the sovereignty of the Westminster Parliament. Understandably, this has created tensions between the component parts of the nation, particularly in Scotland. So most recently, on the 29th of January 2020, the Scottish Parliament agreed to a motion to ask for a second Scottish independence referendum. So if you want to know the next case where we're going to end up with cameras outside the Supreme Court, this will be when either the Prime Minister refuses to give consent and someone brings a legal challenge, or when, having not had consent, Scotland says, well, there's no law definitively saying this is not within the scope of our powers, so we're going to enact a law ourselves for independence and see if we have the power to do so, and that will go to the Supreme Court. This is where we may be heading because of this tension. Because not only have you not followed their wishes with Brexit, but there isn't this element of being able to enforce these consent motions because of the way the UK Constitution is structured. In Wales, the tension is different. They're pushing for more involvement. They want more governmental interactions so Wales can take part in these discussions and deliberations. They would like to put the Sewell Convention on a legal basis so that it can be enforced and protected. And they want more collaboration at the decision-making stage because in some senses, Brexit also poses opportunities for the Union to grow much stronger because it provides for delegated legislation to be made by Westminster and the devolved ministers acting together. So if we had good frameworks, good interactions, then this could strengthen the Union with Westminster and the devolves acting together to achieve this, and this is what Wales wants. So the tension can go in different directions. And then that brings us to Northern Ireland. because the situation in Northern Ireland is incredibly complicated. And if I did explain it to you, you would be here for another 3 hours. So the best I can do is to give you an example of some of the tensions that are there. Northern Ireland has a border with another EU country, a land border with Ireland. There is a whole history of tension between Northern Ireland and Ireland. One of the great successes of the European Union has been the way in which this has led to greater integration between Northern Ireland and support of the EU in favour of the peace process to further these integrations in the community. You're moving towards a hard border, but they're used to a fluid border with integration, with common agricultural markets, with common energy markets. So it's going to create problems and tensions. Hence we have the protocol on Northern Ireland to try and deal with these tensions. And it deals with this by seeing Northern Ireland as part of the same customs union as the UK and having a not hard but sort of semi-fluid border between Northern Ireland and the UK, where goods at risk of going from Northern Ireland to the EU have to be controlled and checked, and those that aren't can come through freely. How we work this out, we're not yet quite sure, but we'll be putting these things in place. The difficulty is this can be renewed. But the UK has decided this will be renewed by a simple majority in Northern Ireland. But in Northern Ireland, you have very strong tensions between those people in Northern Ireland who wish to remain part of the UK and those who prefer to join Ireland, and it's very evenly split. So to deal with this, when there are certain important issues, you have to take decisions through a very complex process that allows to show an agreement of both sides. That either has to be a majority of both sides, or in the Parliament, a 60% majority of the Parliament as a whole, with 40% each of either side, to make sure you're respecting both sides. But not for this, which is either going to push them to see this as an important issue and push to have that process anyway, or it will start undermining this idea of trust. So this huge tension in Northern Ireland, not just with the protocol, but how we move forward and how we deal with this. And again, it could be an opportunity for greater integration, but if it doesn't work, it could push towards a border poll, because the people of Northern Ireland have the ability to decide by referendum whether to join Ireland or stay in the UK. And there's a legal commitment on behalf of the government to implement the wishes of the people of Northern Ireland should they wish to join Ireland. So we'll have to wait and see if the tensions push towards that situation. All of this is illustrating these deeper problems between Parliament and the people, between how democracy works. Now we know the UK has a flexible constitution. It can modify over time. It's not been codified. And we've seen it bend and move and shift to negotiate through Brexit in a way that tries to balance these tensions without breaking the constitution and without the institutions collapsing. But we haven't really thought through fully how we see the sovereignty of Parliament and the sovereignty of the people. We understand it traditionally that the people come along, vote every now 5 years for their general election, they elect the Parliament, and the Parliament has the power for 5 years and then gets voted in by people again at the end of the parliamentary term. And that's how we see it. But Brexit has caused huge amounts of tensions because we asked for a referendum. And suddenly we had this tension between representative democracy and direct democracy. Because the people voted leave, the majority voted in favour of leaving the European Union, but at the time, most of the MPs in Parliament were in favour of remaining in the European Union, which caused huge amounts of tension. So the question is, how do we deal with this? How do we balance the wishes of the people and the wishes of Parliament? Now, the reason I'm giving you these legislation to illustrate is to show you just how flexible the UK Constitution can be. We got a general election Because even if you have legislation fixing parliamentary terms, you can have later legislation that overrides it. And it shows you just how flexible this aspect of parliamentary sovereignty can be. And whether we see this as pushing more towards direct democracy, it was to get an earlier general election to ask the people what they wanted, or whether this is undermining democratic institutions and how they work. So the Fixed Term Parliaments Act fixes parliamentary terms to 5 years, but there are various escape routes. One of the escape routes is if you can get 2/3 of the entirety of the House of Commons, so 2/3 of all of the 650 MPs voting for an early parliamentary general election. The Prime Minister tried this 3 times and failed. Okay, he didn't get the votes he needed to trigger an early parliamentary general election. The last time was on the 28th of October. So on the 29th of October, you get a piece of legislation being introduced, the Early Parliamentary General Election Act, which says we're going to have a general election on the 12th of December. This then gets passed and enacted through, and it can overturn the requirements. Now, if you're used to a constitutional system, this just looks odd. How can you have a piece of legislation that says you need 2/3, and then you have a simple majority that gets rid of it and gets around the 2/3 requirement? And the answer is the doctrine of implied repeal. We impliedly repeal the requirements and move on and move it to the people. We haven't thought it through properly because we didn't think about what the consequences of a referendum would be. We squared it by saying a referendum is advisory. It just gives a political viewpoint. Here you are. This is what the people think. Off you go, Parliament, deal with it. But it isn't just advisory in reality. Legally, it has no legal force. Politically, you've just asked people directly a specific question. You've given them a yes-no outcome. It's very hard to ignore what they have said when you have said in legislation, we have decided this is an issue that goes to a referendum. We have decided you, the people, have the chance to say in a referendum what the outcome will be. And you could see that. Immediately Parliament moved away towards, well, if this is the outcome of the referendum, we have to go and implement it. And not only do we have to go and implement it, but we can push back against legal requirements if we think this is undermining what the people said in the referendum. So we're back to the Surrender Act. The people want to leave because that's what the vote said. Parliament has said you have to ask for an extension. So the context is, but if I ask for this extension, am I undermining the will of the people as expressed in this referendum? And if so, do I have to follow their will, not the will of Parliament? But the question is, are you really following the will of the people now, because the referendum was a long time ago? Are you really following what they wanted? Because there wasn't a vote for hard Brexit or leave with no deal. There was a vote to leave, because referendums can only ask you yes, no, not what about all these possible options and what form of Brexit do you want? So how do you balance these issues? Not only have we not got constitutional limits, but even the limits we have, we're moving to get rid of them again. So the Fixed Term Parliaments Act was used to try and place limits on parliamentary terms. It places limits on parliamentary terms to 5 years, and it means it takes away the hands of the power of the government to decide when to have a general election. Because if the government has the power to decide when to have a general election, it can choose a moment that works for its political party. So it's seen, move it to a fixed term, takes that away. We know from the Queen's speech, this Act will be repealed. We don't know what it's going to be replaced with, but the suggestion is it will be replaced with going back to the monarch will be asked to dissolve Parliament when the Prime Minister wants it to be dissolved in order to have a general election when it suits the Prime Minister. So again, you're moving political controls, you're moving potential checks on the powers if you move in this direction. And this is why I think there are dangers of populism in the UK, because you can tell we haven't distinguished between the pouvoir législatif and the pouvoir constituant, because I've had to steal the terms from French. We don't have these concepts. Parliament enacts normal laws, it enacts constitutional laws, they are all the same. There is no thought about whether if it's constitutional, does it need a different process? Does it need to involve the people more than ordinary laws? We just don't think about it. We enact laws, we move, we change, laws come in, laws get repealed. That's how our constitution works. There are no legal limits on how we enact legislation. It's all done by rules in Parliament. The Commons can vote on them, the Commons can vote against them. Depends on how many people you have in Parliament. But that means it can be very difficult for Parliament to control and check someone who says, I'm doing this on behalf of the will of the people. If there are no legal rules that you can use and you have a strong majority, it can make it very difficult to make sure there's proper scrutiny of those rules as they go through Parliament. We don't explain what the relative powers are, which means we don't say the Supreme Court has the power to go away and develop constitutional principles of the common law to hold the government to account. We see it as implied as inherent power of the court, but it leaves it vulnerable. It leaves it vulnerable to someone to say, well, actually, I don't think you should have this power. I think this isn't about law. I think this is about politics. The dangers get exacerbated by referendums. Because when you have a referendum, you take a whole range of viewpoints and you slot it into yes and no. And the majority becomes the will of the people. So we call it the homogenization of the will of the people. The people now just have this one voice. It doesn't matter that it was a majority, and so the minority are now not part of the people. It doesn't matter within that majority that they might have voted for different reasons. How it's interpreted and read is the one voice, and that is concerning because it cuts out deliberation and discussion about the way ahead. We're starting to use more and more rhetorical arguments, and we're able to do this in the UK Constitution because we're flexible, because we don't distinguish between constituent power and legislative power, because we can just change the rules, because it's so much is done by politics and not by law, and we can move things away from law towards politics, so it no longer has the legal checks. And we can do this in particular because of the way in which we structure our parliament. We call it an arena legislature because we have first past the post. We produce strong majority governments. The role of the opposition is to shout against the government. Even the Speaker criticised the Prime Minister on the day when Parliament came back for using these strong statements, for collapsing almost into shouting matches, rather than taking a step back and deliberating and discussing the consequences of the Miller decision and what it means for the Constitution. Instead, it was just move on, back to Brexit, back to arguing about whether this was the right thing to do. But if Parliament can control its own controls, there's no ability to put the rules in place that can be legally enforceable to make sure democratic scrutiny takes place. And that, for me, is the danger. The question is, should we move to a written constitution? And I'm going to leave that for you to tell me as well, because I don't really have an answer. I do think now is not the right time. Maybe later, maybe when we've got more time to reflect and discuss, then we need to think. But I think what Brexit has shown us is the weaknesses of not having some form of legal checks and balances. And for me, that is the real issue. We need to spend a lot more time thinking about what is political and what is legal. We need to spend a lot more time thinking about when you use referendums and when you don't. Not just having a system where the legislature can say, oh, we'll have a referendum on this. We need more rules about when referendums are suitable. And we also need to take a step back and actually ask ourselves, is there this distinction between the power to establish a constitution that sets the rules and the normal lawmaking power? Because without thinking that through and without having that distinction, I think we are running into real potential problems in the future. Thank you very much for listening to me.
you very much, Professor Young. We'll now take a few questions from the audience. There are some. Who would like to start?
I have an easy question for you.
Okay, good.
Can I just stand up? Easy question. Are you optimistic or are you pessimistic?
That's not an easy question.
A simple question.
A simple question, yes. Can I be optimistic and pessimistic about my stay here? I'm very optimistic about my stay in Belgium. I'm probably more pessimistic than optimistic at the moment. My reason being just because there was such a large move in the general election, and we'd seen a system where we had more of an ability to have checks and balances because we didn't have the strong majority. We've now moved to a very strong majority. Within the political party, the new leader, Boris Johnson, is much more in favour of so harder than softer forms of Brexit, and that leaves me more pessimistic in terms of where we may end up with a future deal, and it also leaves me more pessimistic in how democracy and checks and balances will work. So I'd love to say I'm more optimistic, but at the moment I'm not. And it's not just this provision. So the other provision that scares people a lot with the latest legislation, Henry VIII clauses, which is a clause that allows the government to enact delegated legislation that can override and modify prime legislation. There are lots of them, and they're becoming more prevalent, and that is a real cause of concern. And also in this legislation, an ability for the executive to tell the courts the extent to which they are bound by the decisions of the Court of Justice of the European Union after completion date. Yeah, that worries me as well, and that's why I'm pessimistic. Yeah, thank you.
During the coalition government, there was an attempt to reform our voting system,
That's right.
reform the House of Lords, etc., etc. And there was a referendum,
Yes.
which was basically of no interest
Yes.
to the people. Do you think there is enough interest within the people for a fundamental review and of the creation of the Constitution? And the current Prime Minister is talking about a major reorganisation of
right.
the way government works. Do you have any sense of what his motivation is?
Okay. Thank you. You're right, there was the referendum, and there's a very, very poor turnout to modify voting systems, and a lot of that was due to a lack really of publicity and enthusiasm of what was going on. And also I think there wasn't a large amount of explanation of what the consequences would be and what the outcome would be. I don't think at the moment there is an enthusiasm amongst the people for voting reform. There's an enthusiasm amongst political scientists and legal scholars, but I don't think that has been transferred through to the people as a whole. And that's despite a system where you do have different voting systems in Scotland, Wales, and Northern Ireland. So there just doesn't seem to be, for Westminster, the same enthusiasm. I think at the moment it's really, we're fed up because this is all we talk about. And so I can understand this element of wanting to move on because it has taken over and it is stopping other forms of discussion and deliberation. In terms of the constitutional reform, it's very difficult to know precisely where this is going because the manifesto of the Conservative Party was quite vague. But it was prefaced with statements about concerns of the zombie parliament, this description of Parliament not being able to do anything and the government not being able to do anything and Parliament acting to stop the will of the people to implement Brexit, and that was very much prefaced. Some of the phrases in the manifesto are similar to phrases that were used in earlier manifestos that were then used to reduce judicial review, the ability of courts to review administrative action. So the feeling is that's the direction. We don't really know other than the repeal of the Fixed Term Parliaments Act, which is on the agenda, but we don't know what it's going to be replaced with, and we don't know when yet. So we're still trying to work this out. One deeper concern is the way. So the Conservative Party manifesto has set up or will be setting up a commission on the constitution, democracy and rights to look at these issues. But it's a commission, which means it will be appointed and probably be experts who will go away and discuss this. The referendum, the manifestos of some of the other political parties wanted to move to more citizen assemblies, to have citizen assemblies, to involve the people in thinking about what these constitutional principles should be. And for me, that is a much better way to go if we're going to reform the constitution, to take it to citizens' assemblies, to discuss these issues in more detail, to look at specific issues and then pass them on. Now, it may be the Commission comes up with suggestions that can then go to the people, but we don't know. We're still very much in doubt as to the direction we'll be moving.
Il faut bien que quelqu'un vous pose une question en français.
Merci beaucoup.
Oh. I'm a man from Cambridge University and Brussels University.
Okay.
Very glad that you're here. I share your pessimism, I have to say. I've always thought since my Cambridge days that the unwritten constitution was not worth the paper.
It wasn't written on, yeah.
It's not written on, indeed, in the old cliché. I've enjoyed, in quotation marks, the last 9 months of constitutional fascination, where we see the possible protections from the court and from the legislature. But and I cheered at the judgment in Miller 2 as simply a fantastic piece. But we're back in the elective dictatorship that Lord Helsham described. And frankly, I agree with you, now is not the time to move to a written constitution under the present government, but when is there ever a time?
Exactly.
So that much by way of agreeing with you, but a question. It seems to me, aside from all the other dangers that you've identified, the danger is to the Union, United Kingdom.
Yes.
In Northern Ireland, the links to the south have grown stronger with the open border. Sinn Féin has done well in the elections, would have done better if only put up more candidates. And we know that in Scotland there's a strong movement, resistible as a legal matter, but as a matter of the will of the people, not resistible.
Yeah, agreed.
Which do you think more likely?
Ooh.
Losing Northern Ireland or losing Scotland?
Ooh, that's a tricky one. They'll play this back in 5 years and go, that constitutional expert got this wrong, won't they? It is a political. I'm going for Scotland. I think there's more of a will for Scottish independence at the moment. I think Northern Ireland might take longer, and it will depend on how it works. So my guess at the moment, I think there's more in Scotland than in Northern Ireland. Also because Northern Ireland has just got its parliament back. So up until January of this year, Northern Ireland had about 3 years of being governed by civil servants. And now it's just starting to get its democracy back. It's just starting to set itself up. I think Northern Ireland is going to concentrate more on strengthening that, I think, probably. But you'll probably find in 5 years' time, you'll be saying, she got it completely wrong, and it goes the other way. But just as a political guess, at the moment, I would say Scotland before Northern Ireland.
And with what rough chances?
Now you really are pushing me. It is. It's very delicately balanced. It will depend. The timing is crucial. In some senses, a referendum later, when we've seen the impact of whatever deal, if we have a deal we have, what its impact will be, in some senses later, I think, might push more towards independence. There's also going to have to be lots more discussion in the background of a lot more thought put in before you have the independence of how you divide it. So do you end up with a really odd situation if you have an independent Scotland that has a kind of almost EU-esque relationship with the UK? I mean, are we going to still have closer union in some senses, even with independence? There's a lot of thought and ideas that are going to have to come into this. And lots of economic issues that will have to be discussed, because although Scotland does have some fiscal independence, and is still quite dependent on grant transfers from Westminster as well. So I think there are lots of complex issues that need to be discussed. It will take a long time to unpack those. And I think,
the economic arguments
no,
going to sway.
No, not at all. It's going to be
The mojo of the people is
absolutely,
not out.
absolutely. And I think that is what will sway is going to be the emotional commitment, what the consequences of whatever deal are, and how that impacts on the people of Scotland, and whether they still feel consistently ignored. That doesn't matter. And this is why I think the Sewell Convention is so crucial, and why really, if you're going to repair relationships, these joint decision-making powers have to be joint. They can't be Westminster says we're enacting this, now go away and agree it. That will just split the union way too far. Yeah. Right.
I would like to ask.
I'm going to come up here. There you are.
Okay. Can you hear me now? Sorry.
That's going to be easier, right?
Okay, I'm sorry.
It's all right.
Were there not any other important cases before that aroused the question of the checks and balances systems? I mean, through this entire period of the function, let's say, couldn't the debate between the legal and the political system be prevented? I mean, why now? Why in that case of Brexit?
Okay, thank you. I'll go down and repeat the question so you can all hear. So it's a really interesting question asking about why was it these cases around Brexit that causes issues? Had there not been cases beforehand trying to think about legal and political controls? There had been some cases, but I think Brexit motivated people far more to use the courts than before. And I've only talked to you about the two key cases that got to the Supreme Court. There were lots of other cases that tried to use the courts. Some succeeded, some didn't, and didn't get permission to push this. Because we are in a system where we rely mostly on judicial review rather than constitutional law cases, we don't get very many cases that come to the UK courts that are about the Constitution directly. They mostly come up indirectly. So they mostly come up because an individual wants to challenge an administrative action, and then when they challenge this action, something to do with the Constitution might get raised indirectly. So there were some cases, but they're very few and far between. So we did have cases on how far you can control these prerogative powers, but you're looking at one case in the 1980s, another couple of cases in the 1990s, and then these. So they don't come up very often because the circumstances tend not to come up very often. And I think because you had such unusual circumstances, and because there was such strong feeling, people were much more willing to go to the court and to raise arguments that on constitutional terms were quite novel before we got to these two cases. So in the first Miller case, most people thought, we're not sure they're going to win here, because it's really going to take the Supreme Court to push the law along in order to succeed. And the Supreme Court felt there was enough direction to move along, and it drew on older cases and pushed the law along and accepted that it could have this control in this area. I don't think any of us thought that you were going to get 11-0 prorogation as unlawful. In the run-up to that case, in both first instance cases, they had said this is political, not legal. And it was very much phrased on, can we control how this power is exercised? And the argument was, well, no, it's just politics that determines that, not law. And it was really the appeal decision in Scotland that started changing direction, and the way in which the Supreme Court decided it in a way that wasn't the same as how it had been argued. So the arguments were still, this was an unlawful exercise, but the Supreme Court went for, it does not go that far. So this is why they're so important. They are pushing existing case law much further.
And it just gave an arena in which we could discuss these, because people were much more willing to go to the court and much more willing to raise constitutional limits in a way they hadn't done beforehand. But it was a very interesting question. Thank you.
We'll take a last question.
I don't know whether there's any point in having that.
I can hear you. You'll be fine. I'll repeat the question for you.
So it works at least for, for that purpose. You mentioned Northern Ireland. You said that when implementing the protocol in Northern Ireland, the British government has said they're not going to follow the procedures which usually apply in Northern Ireland. Is that compatible with the Good Friday Agreement? Okay,
technically yes, but in the kind of underlying principles, no. And this is where the tension arises. So technically, there's nothing specifically in the Good Friday Agreement that would require that process specifically for this. It's more an understanding that because this is such a constitutionally important issue, it would be much more in line with the spirit of the agreement to make it a consociationalism process rather than a straightforward simple majority. And this is the problem again. It's how far do you just stick with the letter of the law, and how far do you think about the consequences, the reality, and understanding the background principles of how democracy works in Northern Ireland. So yes, it's one of those lovely aspects in English law where we like to say there's the letter of the law and the spirit of the law, and they don't always say the same thing. I think we all do this, yeah. Okay, thank you.
Last few words, first of all, to thank you very much for your talk, for the answers to the questions. For somebody who's not a legal scholar, I thought about an interest in the Brexit because of personal reasons, and having watched, I remember we've watched the BBC News and the Parliament sessions and the order that we've been hearing. You've made things much clearer for me, and so thank you very much for that. I would also like to thank Emmanuel Slautsky and Iseult Maric, I don't know if she's there, who organised your welcome. They're both alumni of the Foundation, so they do certainly make the Foundation proud by being carrying on its activities. And I'd like to thank everybody, and I think they'll still have the chance to talk to you if they would like to ask some questions. Thank you very much.